Okay, thanks for joining us for our conversation with Ellen Aprill. Professor Aprill is the John E. Anderson Chair Emerita in tax law at the Loyola Law School in Los Angeles. Is that the right?
Correct.
Ellen recently retired. How's it going, Ellen, by the way?
It isn't more of an adjustment than people might think.
Are you working harder?
Yeah. At least my husband thinks so.
Okay, yeah.
You don't have the same breaks to do some of the administrative and other work you do.
Yeah.
And so it's a very different rhythm.
Okay. Ellen will be honored and celebrated later this March by the law school for her career and her accomplishments during it. I think that might be, well, later this March, we'll say. We can put in the post when. I do have a feeling, though, as she just sort of intimated, that she might be just getting started with some of her accomplishments in studying and engaging in public discourse about nonprofit tax law. Let's talk a little bit about your career itself first, and then do a little bit of taxation of endowments 101 for me, which I need for fun. When did you join the law school there, Professor?
I joined the law school in 1989 after 2 years in Treasury's Office of Tax Policy.
And what has changed in legal academia since then?
I think we are still adjusting to all the changes from the pandemic. We are adjusting to the long distance learning, when it's good, when it's not good. The students have been weary and they need to come back a bit as well. And that makes a challenge. It's a different kind of connection that needs to be reestablished.
Mm-hmm. And how's this for an unfair question, but I'll ask it anyway. What has changed in nonprofit tax law?
Well, in some ways a lot, and maybe in some ways not enough. That there are lots of issues on which we could use guidance, we could use IRS enforcement, and we don't see it.
And when you say guidance, you mean from the IRS?
From the IRS.
Right. Okay. Oh, interesting. Now I want to ask a bunch of questions about that, but what's the problem? Their resources?
Largely, it is their resources.
Right.
A little bit, it's also that we exempt org people feel as if we're a bit of a stepchild for the IRS. The IRS gets its brownie points for raising revenue. You don't get a lot of revenue from enforcing nonprofit law. As we will talk about later, the provisions, especially for private foundations, are regulatory. They're regulations in the form of taxes. They're not for revenue raising. So it's quite a different task for the IRS.
Mm-hmm.
And doesn't always get the highest priority for reasons I think we can understand.
Mm-hmm.
If you're talking to Congress about how much revenue you're raising,
mm-hmm.
you're going to look elsewhere to put your enforcement efforts.
Mm-hmm. And you, for how long, have been sort of helping to put together the Western Conference on Tax Exempt Organizations?
We are about to we're starting to plan our 27th year.
Yeah.
Putting on that conference.
Yeah. And the last one was in December. Are they always in December?
Yes, we try to avoid some other conferences, and we're very happy that we have lawyers, accountants, in-house people. Many accountants have November 15th deadlines for 990s, and we want to make sure we have the conference after they finish that big task.
Right. Okay. What were some of the hot issues at the last one?
Well, like everybody else, how do we get a hold of the IRS these days? Who's answering the phone? And because there has not been a lot of enforcement action from the IRS, a lot of interest in what state attorney generals are doing in terms of enforcing nonprofit laws.
Are state attorneys general better resourced? I mean, wouldn't the same problem apply before revenue versus regulation?
Yes, and some states do very little enforcement, but state attorney generals are not tasked with raising revenue.
Oh,
Trying to enforce the laws are more with regulatory laws are what they do. And so doing it for charities, at least for those states that have charitable arms within AG, is a little bit more of a fit.
yes, okay. All right, let's talk endowments then for fun.
Okay.
I have a law degree and I must have taken tax. I certainly didn't take nonprofit tax. Is there a course that you've taught nonprofit tax, or do you teach tax with a nonprofit emphasis? Or
No, I sometimes I teach a nonprofit organizations class, which was about half state law and half federal tax law.
yeah,
For our master's program, I have set up a course that is just about taxation of
yeah.
exempt organizations.
So I used to work at a private foundation on the program staff, nothing to do with any money, I mean, I know there were grant award amount. And I thought private foundations were tax exempt, but they apparently pay taxes. How did that happen?
Well, first of all, even 501c3 public charities, we talk about them as taxpayers. Almost all of them pay some payroll taxes.
Yeah.
So to that extent, they are taxpayers.
Mm-hmm.
When the 1969 Act happened, which created the distinction between public charities and private foundations, there was felt a need to audit private foundations to avoid violations of these new rules. And the tax on the investment income happened at that point, and it started out at 4% of their investment assets. And since it was supposed to be sort of for money to audit private foundations, and they thought they might be auditing lots and lots of them, it went down to 2% because they discovered that 4% generated more revenue than they needed to administer all the exempt org provisions. So it went down to 2%. And then there was quite a period where we had a somewhat complicated provision that it started out at 2% and it could go down to 1% if the private foundation increased its distributions. And then in December of 2019, they put it to a flat 1.39%. Of course, we would pick 1.39%, a nice, not round number.
Mm-hmm. So you couldn't, as a private foundation, essentially buy your way out of the tax by making more
So
grant.
part of the reason it got changed is that private foundations that increased their distributions felt caught by this provision because then their baseline would have been raised. So in a way, it discouraged them from increasing distributions, particularly in times of great need. And after asking for many, many years to at least change the provision, if not eliminate it, this is the compromise, or
Yeah.
this is what Congress decided.
Is there an answer to the question of why 1.39?
So supposedly when they changed it, the promise was to make the change revenue neutral from the 2%, 1%. And though I haven't talked to the revenue estimators about this ever, my guess is that this was the number that looked like it was going to be revenue neutral.
Yeah. Okay.
And now that we have all these ways to do calculations, who cares if it's a nice round number or not?
Yeah. Okay. All right. Then the section 4945 excise tax provisions are the ones are similar to, or are they the ones we think about when we think about what a private foundation can or can't do? Is that describe to me that section?
So that section of taxable expenditures is sort of a potpourri of no-nos. They are not necessarily completely coherent. They forbid lobbying by private foundations. Now we need to remember that private foundations are a form of 501c3s generally, and both public charities and private foundations are prohibited from engaging in campaign intervention. We were talking about calling it electioneering or politicking. Public charities can engage in some lobbying, but 4945 prohibits it for private foundations.
And what happens to me if I'm a private foundation and I violate that prohibition?
You get a nasty excise tax. These two-tier excise taxes can get very big very quickly, and therefore they really are designed to regulate, prohibit activity, not to raise money.
Yeah.
So there's lobbying. There are limits on get out the vote. So 501c3 public charities can engage in get out the vote efforts if they are nonpartisan. And nonpartisan is defined such that you can do it in a zip code where everyone you register is almost surely going to be one party or another. You just can't say, I'm only going to register you if you are the particular party I favor. At the time that the 1969 Act came into being, there was a lot of animosity by Wright Patman towards the Ford Foundation. And McGeorge Bundy didn't win himself a lot of friends when he testified.
Mm-hmm.
And this limit on when private foundations can get out the vote, minimum number, it has to be carried out in 5 or more states and not for a single election. I am pretty sure it was aimed at the Ford Foundation. Now, the get out the vote being technically nonpartisan for public charities is something we have seen a lot of criticism about in the last couple of elections, but we don't have to worry about private foundations doing that. There are also rules about scholarships and grants to individuals. So they need private foundations to do that, have to file something with the IRS, and they get permission if the IRS doesn't say no. I have encountered over the years a lot of very small family foundations who have no ideas about these rules.
Yeah.
And they think they can give scholarships whenever they want. There are special rules about dealing with government officials. There are rules about grants to non-501c3s and foreign entities that require something called expenditure responsibility. Yeah. So there are a bunch of things in there.
Yeah. If I can just on the politicking bit.
Yeah.
I mean, there are things that a private foundation cannot do in that area. And there are things that public charities cannot do in that. I mean, you know, I'm on this. You said that we don't have to worry about private foundations.
No, if they're following the rules.
Exactly. That's all I really want to know.
And there are a whole bunch of exceptions. So there are exceptions if you're invited to testify. There are exceptions if it's nonpartisan analysis and research. And you have to make that widely available. That used to be hard. Now it's easy. You just post it somewhere and you make it widely available.
Yeah. When I was at a foundation, I recall being told by the attorneys you had to fairly cover both sides of an issue.
In order to be educational, it has to have full and fair exposition.
This is an unfair question because are these rules treated as a joke?
Are they treated as a joke? Not among the people I know, the fancy lawyers who get paid to do it. But I do worry about small foundations. I think that Professor Jim Fishman of Pace wrote an article not long ago suggesting that small private foundations really should turn into DAFs, donor advised funds, because they don't know these rules, they don't have the money to follow them, and it's not intentional missteps, but just not understanding how complicated the rules can be.
Right. Okay. Why don't we finish up with part 1 there? See, time goes by so fast, and we'll come back and talk about higher education endowments.